Practice Test 11. Law and Reference. Question 1. As required by the Immigration Reform Act, all employees hired on or after November 7, 1986 must complete which form, I-9, to verify their employment eligibility status? Immigration Reform Act, hired employees after November 7, 1986 must complete Form I-9, to verify eligibility status. Immigration Reform Act, after November 7, 1986, employee must fill out Form I-9 to verify eligibility status. Question 2. By law a hard laborer may not be younger than 16 years of age. A hard laborer may not be younger than 16 years old. Minimum age of hard laborer is 16. Question 3. Ms. Gomez applies for a job. Of the following, the only reason an employer may lawfully deny her employment is: she has no work experience or social security number. Lawful reasons for denying employment are: no work experience or social security number. No work experience or no social security number are lawful reasons to deny employment. Question 4. A contractor has had a problem with employees stealing tools and equipment from job sites. When conducting job interviews, may the contractor ask prospective employees about their arrest records. It is not legal to ask prospective employees about arrests not leading to convictions. It is not legal to ask prospective employees about arrests not leading to convictions. Employers may not ask prospective employees about arrests or convictions. Question 5. Who must sign a joint control addendum to a home improvement contract? Owner, contractor, and joint control officer. Joint control addendum requires owner, contractor and joint control officer to sign on contract. Owner, contractor and joint control officer must sign contract for joint control addendum. Question 6. A contractor entered into a home improvement contract for more than $500 with Mrs. Swenson to remodel her kitchen and bathroom. The contract calls for a down payment before work is to begin. According to the Business and Professions Code, how much may the contractor accept from Mrs. Swenson as down payment for the work? The down payment is limited to $1,000 or 10% of the total price, whichever is less. Contractor may accept $1,000 or 10% of total price, whatever is lesser as a down payment. How much may the contractor accept as down payment for the work? The down payment is limited to $1,000 or 10% of the total price, whichever is less. Question 7. When should you let an attorney see a construction contract? After the contract is prepared, but before you sign it. An attorney should review a contract after it is prepared, and before you sign it. Have an attorney should review a contract after it is prepared, and before you sign it. Question 8. If a sales presentation is made in Spanish, the home solicitation contract must be in Spanish. If the sale presentation is in Spanish, the contract must also be in Spanish. Sale presentation in Spanish, the contract must be Spanish also. Question 9. A contractor and a homeowner sign a home solicitation contract. If the owner lawfully cancels the contract, how long does the contractor have to pick up unused materials that were delivered to the owner's property? Within 20 days after cancellation. A contractor has 20 days to pick up materials from a job site after the owner has canceled. Owner cancels, then contractor has 20 days to pick up materials from the site. Question 10. Of the following, which is best for determining the number of hours required for different phases of a project and for making sure the job is on schedule? Critical path method. Best for determining the number of hours required for different phases on projects and staying on schedule is critical path method. Critical path method is best way to plan hours on each phase of job and to stay on schedule. Question 11. Who is responsible for checking the site before the building inspector arrives? Contractor. The contractor is responsible for checking the site before inspector arrives. Before the inspector arrives, the contractor is responsible for checking the site. Question 12. Who would be held responsible if a contractor completes a project according to plans and later discovers that there is a building code violation? Both the contractor and the architect. If a building code violation is found, The contractor and the architect must be notified. Inform the contractor and architect if a code violation is found. Question 13. After a job is completed, the owner decides to have additional work done. How should the contractor proceed? Write a new contract and ask the owner to sign it. After job is done, owner wants to add more work, contractor needs to draw up a new contract and have owner sign it. Owner wants more work after a job is done. Contractor needs a new contractor and have owner sign it. Question 14. You have been awarded a job. It requires 2 days for site preparation and 1 day for cleanup. The contract involves 2 separate tasks, one lasting 7 days and the other 10 days. If the 2 tasks can be done simultaneously, for how many days do you schedule the job? 13 days. Job has 2 days of site preparation, 1 day cleanup. Contract has 2 tasks, one is 7 days, the other is 10 days. If done at same time, job should be scheduled for 13 days. Job has 2 days prep, 1 day cleanup. 2 task, 1 task 7 days. Other task 10 days. Done at same time, job scheduled for 13 days. Question 15. For which of the following would you not obtain a short-term loan? Office rent. Do not obtain a short-term loan to pay office rent. Do not use a short-term loan to pay for office rent. Question 16. As part of the safety training process, contractors' supervisors are required to conduct toolbox or tailgate safety meetings. How often must these meetings be held? At least once every 10 working days. Contractors' supervisors are required to conduct toolbox or tailgate safety meetings held once every 10 work days. Required tailgate, toolbox safety meetings once for every 10 work days. Question 17. DOSH must investigate a complaint charging a serious violation of health or safety standards within 3 working days. DOSH investigate serious violation health, safety within 3 days. DOSH must investigate serious violation of health and safety within 3 days of complaint. Question 18. Every employer of X or more full or part-time employees must keep written health and safety records for X years. 11 employees, 5 years. Employers with 11 or more full or part-time employees must keep written health and safety records for 5 years. Must keep written health and safety records for employers with 11 employees for 5 years. Question 19. If required safety devices are missing from tools, what should an employee do? Notify the contractor, who is responsible for safety. Safety devices are missing from tools, employee should notify contractor who is liable. Employee finds missing safety equipment on tools, notify the contractor who is responsible for safety. Question 20. Which would not have to be reported to DOSH immediately or within 24 hours? Car accident in which an employee steps onto a public road, gets hit by a car, and suffers a concussion. Employee no seriously hurt such as death or falling off roof, unrelated job site injury, is not required to report to DOSH immediately. Employee not seriously injured or life-threatening on the job is not required to be reported immediately to DOSH. Question 21. When purchasing insurance, what is the best way to choose among different companies? Cost and coverage. The best way to choose among different insurance companies is cost and coverage. Best way to select insurance between companies, cost and coverage. Question 22. Insured employers must report every work-related illness or injury to their workers' compensation carrier within blank of the incident. 5 days. Insured employers must report every work-related illness or injury to their workers' compensation carrier within 5 days of the incident. Employer with insurance must report all work-related injury to workman's comp within 5 days of incident. Question 23. Your employee sets a cabinet wrong. The cabinet falls from the wall and damages the client's countertop. What should you do? Claim the damage on your general liability insurance policy. Employee makes mistake and damages unrelated item in work area. Contractor should file a damage claim to general liability insurance policy. Employee makes mistake and damages owner property. Contractor files a claim through general liability insurance. Question 24. A contractor is looking for an insurance policy to cover a high degree of exposure to risk. Of the following, which policy would be best for this purpose? Umbrella. Insurance policy to cover a high degree of exposure to risk is umbrella. Contractor needs insurance policy to cover high degree of exposure to risk, umbrella coverage. Question 25. A general contractor had a contract to construct a gazebo and deck in a backyard. Contractor was behind schedule and hired his 18-year-old son to help on a part-time basis. After working on the project for a month, son slipped on a plank that contractor had laid across the deck but did not nail securely. As a result of the fall, son broke his leg. Contractor is insured for workers' compensation, but son wants to sue contractor for negligence in a civil action. Which of the following statements is correct? A civil action is not a possibility when the dispute involves a job-related injury, unless the employer is not insured for workers' compensation. If the contractor is insured for workers' compensation, civil action is not possible dispute for job-related injury. Civil action is not a possibility when the dispute involves a job-related injury if employer is insured for workers' compensation. Question 26. A prime contractor entered into a construction contract with a subcontractor. An employee of the subcontractor was injured, but unfortunately, the subcontractor had not secured workers' compensation coverage. Which of the following statements best describes the situation, except in case of fraud? The subcontractor is guilty, but the prime contractor must take responsibility for the injuries. If prime contractor hires a subcontractor with no workers' compensation, injury responsibility falls on the primer contractor. Subcontractor without workman's comp has an injured employee, prime contractor is financially responsible. Question 27. Your accountant advises you to set up a cost management system. What does this system do? It gives a cost history to analyze labor and material costs. Cost management system gives a cost history to analyze labor and material costs. Cost management system gives a cost history to analyze labor and material costs. Question 28. An employee works 60 hours in 1 week. If the hourly wage rate is $12 per hour, what are the gross wages? $840. Gross wages is regular time plus overtime. Regular time is 40 hours at $12 per hour equals $480. Overtime is 20 hours at time and a half of $12 per hour equals $360. Gross wages is $480 plus $360 equals $840. Question 29. Blank represents a company's financial position on a specified date. Balance sheet. A balance sheet represents a company's financial position on a specified date. A balance sheet represents a company's financial position on a specified date. Question 30. Blank summarizes revenues, costs of sales, and operating expenses over a period of time. Income statement. Income statement summarizes revenues, costs of sales, and operating expenses over a period of time. Income statement summarizes revenues, sales cost and operating expenses over a period of time. Question 31. An employer must furnish an employee with a completed IRS Form W-2, wage and tax statement, by January 31st. Employer must provide furnished W-2 for employee by January 31st. Employer must prove W-2 for employees by January 31st. Question 32. Which of the following financial ratios is the strictest measure of liquidity? Quick ratio. Quick ratio is the most strict measure of liquidity. Most strict measure of liquidity is a quick ratio. Question 33. The Federal Employer Identification Number, EIN, is issued by the Internal Revenue Service. Federal EIN is issued by the IRS. Federal Employer Identification Number is issued by the IRS. Question 34. An employer remits state income tax and state disability taxes withheld from an employee's wages to what agency? Employment Development Department. Employer remits state income tax and state disability taxes withheld from an employee's wages to Employment Development Department. EDD. Employer remits state income and disability taxes withheld from an employee's wages to Employment Development Department. EDD. Question 35. Who pays FICA? 50% employer and 50% employee. Employee and employer both pay 50% to FICA. Employee and employer each pay 50% to FICA. Question 36. How often are FICA taxes reported and paid? Quarterly. FICA taxes are reported quarterly. FICA taxes are reported quarterly. Question 37. Who pays FUTA? Employer. The employer pays FUTA. The employer pays FUTA. Question 38. What happens after an employee's taxable wages exceed $7,000? After $7,000, the employer does not pay FUTA. After $7,000, the employer does not pay FUTA. After $7,000, the employer does not pay FUTA. Question 39. Which of the following may not be deducted from an employee's paycheck? Workers' compensation insurance premiums. Employee may not have workers' compensation deducted from their paycheck. Employee must pay workers' comp, it cannot be deducted from employee check. Question 40. To whom do you report and pay sales tax? Board of Equalization. Report and pay sales tax to Board of Equalization. Report and pay sales tax to Board of Equalization. Question 41. How often are you required to pay sales tax? Quarterly. Sales tax required to be paid quarterly. Sales tax required to be paid quarterly. Question 42. When balancing the accounts receivable, which of the following would have no effect? Posting to the wrong accounts receivable account. Posting to the wrong accounts receivable account will not affect balancing the accounts receivable. Posting to the wrong accounts receivable account will not affect balancing the accounts receivable. Question 43. What kind of discount do lumber yards and other suppliers offer to contractors who pay their bills promptly? 1% to 2%. Lumber yards and other suppliers offer discounts to contractors who pay their bills promptly of 1 or 2%. Lumber yards and other suppliers offer discounts to contractors who pay their bills promptly of 1 or 2%. Question 44. If a newly hired employee does not have an SSN, what should be done? The employee must apply for an SSN. If a new employee doesn't have a social security number, they must apply for SSN. New employee does not have SSN. Must apply for social security number. Question 45. Once a budget is finalized, the contractor should do the best possible job of staying within the budget. After budget finalization, contractor should do best to stay on budget. After budget finalization, contractor should do best to stay on budget. Question 46. Which of the following procedures best ensures error-free bids? Rechecking the bid before submitting it to the client. To ensure error-free bids, recheck the bid before submitting it to the client. To ensure error-free bids, recheck the bid before submitting it to the client. Question 47. Direct costs are $37,000, overhead is 12%, and profit is 5%. What is the selling price? Sum of overhead and profit percentages is 12% plus 5% equals 17%. Percent of selling price that is direct costs is 100% minus 17% equals 83%. Selling price is $37,000 divided 0.83 equals 44,578.31. Direct costs is 44,578.31 times 0.83 equals 37,000. Overhead is 44,578.31 times 0.12 equals 5,349.40. Profit is 44,578.31 times 0.05 equals 2,228.92. Total is 44,578.32. Question 48. What is the most likely reason to lose a bid? Vague specifications. Vague specifications will lose a bid. Most likely to lose a bid by giving vague specifications. Question 49. You are bidding a job with plans drawn by the owner. You notice a code violation and bring it to the attention of the owner. The owner declines to remedy the code violation and tells you not to worry. What should you do? Decline to bid on the work. If you notice a code violation and the owner wants to ignore it, decline to bid on the work. If an owner wants to ignore a code violation, decline to bid on the work. Question 50. After you have read the plans and specifications, what is the next important step in writing a bid? Walk the job. After reading plans and specifications, walk the job. Walk the job after reading the plans and specifications. Question 51. On a time and materials job, you should add profit and overhead to labor and materials. Add profit and overhead to labor and material jobs. On a time and materials job, add profit and overhead for labor and materials. Question 52. All of the following are causes for disciplinary action except: during bankruptcy, settling obligations incurred as a contractor for less than the full amount is not cause for disciplinary action. During bankruptcy, settling obligations for less than the full amount is not cause for disciplinary action. Settling obligations for less than full amount is not for cause of discipline actions when declaring bankruptcy. Question 53. The qualifying RME for a construction firm must work at least 32 hours per week or 80% of the work week. RME construction firm must work 32 hours or 80% of the work week. Qualifying RME construction firm must work 32 hours or 80% of work week. Question 54. If a contractor forgets to renew his or her license on time, the expire license may be renewed any time within blank after its expiration without reapplying for a license and fulfilling the exam or waiver requirements. 5 years. Contractor does not renew license and it expires. They have 5 years to reapply without full exam or waivers. Contractor has 5 years to renew license after expiration without full exam or waivers. Question 55. Business records must be kept and made available for inspection by the Registrar of Contractors for a period of blank after completion of a construction project or operation. 5 years. Keep business records available for inspection by Registrar or of Contractors for 5 years after completion of job. Keep business records for 5 years after completion of job to be available to Registrar of Contractors. Question 56. Construction or alteration of any building, highway, excavation, or other structure in the state of California requires a contractor's license if the total cost of one or more contracts on the project is $500 or more in labor and materials. Job without license can be done for $500 or less including materials. Jobs can be done without license if cost less than $500 including material. Question 57. When should a contractor renew the contractor's license bond? 30 days before it expires. Renew contractor license bond 30 days before it expires. Contractor should renew license bond 30 days before it expires. Question 58. Harry and Linda have done business as a licensed partnership. If Linda is a general partner, but not the qualifier, what must she do to get an individual license? If Linda was listed as a partner on the license and was actively engaged in the business for at least 5 of the past 7 years, she may apply for a license with a waiver of the exam. As a partner on a license and was actively engaged in the business for at least 5 of the past 7 years, may apply for a license with a waiver of the exam. As partner of license and actively engaged with business for 5 of the last 7 years, may apply for license with waiver of the exam. Question 59. A subcontractor who does not serve a preliminary notice loses both stop notice and mechanics lien rights. Subcontractor does not serve a preliminary notice, loses both stop notice and mechanic lien rights. Subcontractor does not serve a prelim notice, loses both stop notice and mechanic lien rights. Question 60. When an owner signs a receipt for a stop notice, it usually means the owner recognizes that a lien could be placed on funds. Owner signs stop notice, owner recognizes a lien could be placed on funds. Owner signs stop notice, lien can be placed on funds. Question 61. What possible reason would an owner for requiring an unconditional lien release from a subcontractor? The owner's property covered by the release may not be liened. Unconditional lien release from subcontractor covers the owner's property from being liened. Unconditional lien from subcontractor covers owner property from lien. Question 62. The CSLB has established a mandatory arbitration program of verified complaints in which the damages are $7,500 or less. CSLB mandatory arbitration program for verified damage complaints of $7,500 or less. Mandatory arbitration for verified damage complaints of $7,500 or less. Question 63. A contractor usually will not be held liable for a supplier going on strike, but if your supplier did go on strike, what would you do? Contact the owner immediately. If a supplier goes on strike, contact the owner immediately. If a supplier goes on strike, contact the owner immediately. Question 64. If, during an excavation, you unearth human remains or burial artifacts at a construction site, what should you do? Stop work immediately at that site and any other nearby area that may have remains. Unearth human remains on excavation, stop work immediately at any site that may also have remains. If you unearth human remains on excavation, stop work immediately at any site that may also have remains. Question 65. If you are planning to dig, drill, and bore at a job site, you should notify blank before starting work. The Regional Underground Service Alert Notification Center. Notify Underground Service Alert Notification Center before you dig or drill on a site. Before you dig or drill on site, notify Underground Service Alert Notification Center. Question 66. Before beginning work, an employer or contractor must inquire whether asbestos is present in any building constructed prior to 1978. Contractor must inquire about asbestos before work begins if a building was built before 1978. Inquire about asbestos before begin work if a building was built before 1978. Question 67. The supplier of a potentially hazardous product must be able to provide a blank with that product. Material safety data sheet. Supplier of hazardous product must be able to provide a material safety data sheet. Supplier of dangerous materials must provide material safety data sheet. Question 68. Is it legal for a contractor to require employees to take lie detector tests? It is not legal for the contractor to require lie detector tests, but it would be legal for a federal, state, or local public agency to require lie detector tests of their employees. Not legal for contractor to require lie detector tests for employees. It would be legal for government public agency to require lie detector tests of their employees. Question 69. Sometimes contracts can prove to be too vague to interpret without disagreement between owner and contractor. Which of the following steps would best prevent such problems? Review the plans and specifications with the owner. To not have vague contracts and avoid disagreements, review plans and specifications with the owner. Review plans and specifications with the owner to prevent disagreements from vague contracts. Question 70. Funds withheld to guarantee completion of a project and correction of defects are called a retention. Withheld funds to guarantee completion of job and corrections is retention. A retention of funds is to guarantee completion of jobs and corrections. Question 71. Which of the following statements about home improvement laws is not correct? The homeowner may give the salesperson a bonus. The homeowner may not give salesperson a bonus. A homeowner may not give a salesperson a bonus. Question 72. When you get an approved set of plans, what should you do first? Read any notes from the building department. Read any notes from building department for approved set of plans. Read any notes from building department for approved set of plans. Question 73. You are bidding as a prime contractor on a public works project. The work will not involve construction, improvement, or repair of streets, highways, or bridges. You will use subcontractors for part of the work. If you do not name a subcontractor for any part of the work, You will do that part of the work yourself. As a prime contractor, any work not scheduled for a subcontractor will be done by the prime contractor. Any work not scheduled for a subcontractor will be completed by prime contractor. Question 74. A contractor meets to discuss remodeling. The contractor and homeowner sign a contract that includes a 3-day cancellation form. After the contractor leaves, homeowner decides not to have the work done. Instead of using the cancellation form, homeowner sends the contractor a letter by first-class mail stating that he is canceling the contract. Is the cancellation effective? Yes. Mr. Jones's letter does cancel the contract because it indicates his intention not to be bound by the contract. Contact to sales or contractor with intent to cancel is valid, does not have to only be with using cancellation notice of the contract. Any contact to sales or the contractor for canceling is allowable within the deadline. May not lock a customer in within the deadline to cancel. Question 75. A general contractor has obtained bids from several subcontractors for a private project. He notices that one bid is substantially lower than the rest. Is it ethical and a good business practice for this contractor to inform the subcontractor that the bid is substantially lower than the bids of the other subcontractors? Yes. If the contractor has reason to believe that the subcontractor has made an error in preparing his bid, the contractor should notify the subcontractor of the apparent error, but the contractor may not disclose the amounts of the other bids. If the contractor believes that the subcontractor has made an error in his bid, the contractor should notify the sub about the apparent error, but the contractor may not disclose the amounts of the other bids. Sub makes error on bid. Contractor knows it's way off, should inform the sub to double check. Sub makes error on bid. Contractor knows it's way off, should inform the sub to double check. Question 76. A contractor, on his own initiative, changed the design of a building and carried out the change. The owner rejected the change and stated that the building has lost market value. If the owner takes the contractor to court and obtains a favorable judgment, the owner is: do the cost of repairs or the loss of market value. Do not change design of the building without owner signing off, liable for the cost of repairs or loss of market value. Do not change design of the building without owner signing off, liable for the cost of repairs or loss of market value. Question 77. Of the following, which document is usually delivered first in a transaction involving a home improvement contract? Notice to owner. A notice to owner is delivered first in a transaction for home improvement contract. A notice to owner is delivered first in a transaction for home improvement contract. Question 78. The applicant for a contractor's license receives a notice from the contractor's state licensing board, dated October 1st, that the applicant passed the written exam. To receive an active license, the applicant must file a license bond and fee no later than December 30th. After passing written exam, you have 30 days to file a license bond and fee. 30 days after passing written exam for file a license bond and fee. Question 79. How many days does a contractor have to notify the registrar after being issued a workers' compensation insurance policy? 90 days. Contractor has 90 days to notify registrar after issued workers' comp. 90 days to notify registrar after issued workers' comp. Question 80. How many times may you take the contractor's license exam before your original application is voided? As many times as necessary within 18 months. May take contractor exam as many times possible within 18 months. Have 18 months to pass contractor exam. Question 81. You are the qualifier for an active contractor's license. How do you inactivate the license? Write to the CSLB, requesting that the license be made inactive. To inactivate a license, write a letter to CSLB. Write a letter to CSLB to inactivate a license. Question 82. The purpose of a 20-day preliminary notice for private work is to notify the owner that the person or firm who sent the notice has improved the property. 20-day prelim notice. Notify the owner that the contractor who sent the notice has improved the property. 20-day prelim notice. Notify the owner that the contractor has improved the property. Question 83. A notice of completion must be recorded within 10 days after work is completed. 10 days after completion of a job to record a notice of completion. Record notice of completion after 10 days of job completion. Question 84. A mechanic's lien is a written document that must be signed and verified by the claimant. The first and third steps a contractor should take in filing a lien are listed below. Step 1. Obtain the exact legal description of the property. Step 2. Blank. Step 3. Find out if the person requesting the work of improvement is the owner. What is step 2? Find out the name of the legal owner of the property as well as the percent of ownership. Mechanic's lien, written document must be signed and verified by the claimant. The 3 steps are: Step 1. Obtain exact legal property description. Step 2. Find out legal name of property owner and percent of ownership. Step 3. Find out if the owner is requesting the work of improvement. Mechanic's lien 3 steps are: Step 1. Get exact legal property description. Step 2. Get legal name of owner and percent of ownership. Step 3. Find out if the owner is requesting work of improvement. Question 85. When a notice of completion has been filed, the original contractor has blank days to record a lien. 60 days. Contractor has 60 days record a lien after notice of completion is filed. After completion notice is filed, contractor has 60 days to record a lien. Question 86. A subcontractor or material supplier has blank days to file a lien once a notice of completion has been recorded. 30 days. Subcontractor or material supplier has 30 days to file lien after notice of completion. Subcontractor or material supplier has 30 days to file lien after completion notice. Question 87. What does it mean when a subcontractor signs a waiver and release form on a public works project? The subcontractor gives up the right to lien the construction funds. Subcontractor signs waiver and release on public works project means the sub gives up the right to lien the construction funds. Subcontractor signs waiver and release on public works project, sub gives up right to lien construction funds. Question 88. Is it legal for a contractor to hire professional strike breakers to replace striking employees? No. The contractor is subject to a maximum fine of $1,000 and a maximum jail sentence of 90 days. If a contractor illegally hires strikebreakers to replace striking employees, the contractor is subject to a $1,000 fine and 90 days max in jail. Contractor hires strikebreaker to replace employees on strike, contractor faces $1,000 fine and 90 days jail. Question 89. Is it legal for a contractor to pay employees in cash? Yes, if the contractor provides each employee with a wage deduction statement semi-monthly or at the time of each wage payment. A contractor can legally pay employees cash if provides wage deduction statement for each employee semi-monthly or at the time of each wage payment. Contractor can pay employees cash, must provide wage deduction for each employee semi-monthly or at each wage payment. Question 90. A contractor hires a subcontractor to demolish a concrete wall. Who is responsible for supplying safety goggles? Subcontractor. Subcontractor hired to demolish concrete wall, sub responsible for safety goggles. Subcontractor hired for a job. Sub responsible for safety equipment to do the job. Question 91. Some counties have an additional sales tax added to the base rate. Which of the following is a correct statement regarding this additional tax? You must pay the additional tax in the county where the materials were purchased. Regardless where you live, you must pay the additional tax in the county where the materials were purchased. You must pay the additional tax in the county where the materials were purchased. Question 92. Where is the notice of right to cancel found on a home improvement contract? Near the client's signature. Notice of right to cancel will be found near client signature. Notice of right to cancel shall be near the client's signature. Question 93. How long does a client have to cancel a contract for repairs that are the result of an event for which a state of emergency was declared? 7 business days. Client has 7 business days to cancel repair job caused by state of emergency damages. For damages caused by state of emergency, client has 7 business days to cancel. Question 94. Which of the following is considered a direct cost? Payroll tax. Payroll tax is considered a direct cost. Payroll tax is a direct cost. Question 95. Which act establishes the rights of workers to organize into unions and negotiate contracts? National Labor Relations Act of 1935. National Labor Relations Act of 1935 establishes rights of workers to form unions and negotiate contracts. National Labor Relations Act of 1935 gives employees right to form unions and negotiate contracts. Question 96. When is the last day a customer can cancel a contract that was signed on Friday, December 21st? The following Wednesday, customer has 3 business days to cancel a contract. Contract signed on Friday, December 21st. Customer may cancel by following Wednesday, they have 3 business days to cancel contract. Customers have 3 business days to cancel a contract. Question 97. What is the maximum allowed travel distance from any point of a work area to a fire extinguisher? 75 feet. Maximum distance of fire extinguishers from any work area is 75 feet. 75 max distance for fire extinguisher in work areas. Question 98. Why would a contractor have a case in Superior Court? If it is a dispute of more than $25,000. A contractor would have to go to Superior Court if dispute of more than $25,000. Contractor goes to Superior Court for a $25,000 dispute. Question 99. When a subcontractor does work on a public works contract, the public agency considers the subcontractor to be an employee of the prime contractor. Subcontractors are considered an employee of the prime contractor during public works contract. Subs are considered employees to prime contractor on public works projects. End of practice test 11. Law and reference.